Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-5091. Abram J. Harris, appellant versus U.S. Department of Transportation, FMCSA, and United States of America. Mr. Harris for the appellant, Ms. Lyons for the appellees, Mr. Bielert, amicus curiae.
Right. Mr. Harris, if you'll come up to the podium.
Good morning.
Good morning. Morning.
If it may please the court, I am Abram J. Harris, the plaintiff and the appellant. I am not a lawyer, so please excuse me if my presentation doesn't measure up to that bar. The basic facts in this case are not disputed. My case was filed in DC Superior Court. It was dismissed. A judgment dismissal entered, and I filed an appeal to the District of Columbia Court of Appeals. The government then filed a notice of removal in the district court independently, entered a judgment of dismissal after it was made an assessment of the merits. Although I'm not a lawyer, I do understand that Moore's federal practice is considered a standard reference work on the federal court's procedure. It's written by lawyers, judges, and professors who write and amend the federal rules. So I think that when Moore's federal practice says something, we should listen. And what does Moore say with respect to the matter at hand? Absent a specific rule statute, removal statute, such as governing the FDIC, quote, the better rule is that removal to an appellate court is improper unless the removal statute otherwise provides. This approach comports with the general rule that the removal statute be strictly construed, unquote. Neither appellee nor amicus recognized Moore's analysis or case cited therein. Quote, it would seem obvious, the Ninth Circuit has said, that to remove an action in the federal court from the state court, it would first be pending in the state court, unquote. Case Restruder versus Adams in the Ninth Circuit. A state civil action is still pending and thus removable as long as the parties are still actively contesting the case in the state court system. The case has not achieved a final resolution. Case Yemen versus J.P. Morgan and Company in the Ninth Circuit. In the Seventh Circuit. That depends on the state, or in this case, District Columbia law. Under District Columbia law, a judgment or order is final when it, quote, terminates the action in the Superior Court. Case cited Frost versus People's Drugs Store in DC Circuit. Overruled on other grounds by Relinsky versus Lewis. C. Fords versus Chart 1 in the DC Circuit. That is this case here. Once Once a case is dismissed in Superior Court, there is nothing pending in the court to remove. As a matter of logic or common sense, the district court had nothing to remove. The district court had nothing to dismiss. The government removed a dismissal case. Appellee in amicus involves a special removal statute. In addition, these decisions recognize, at least in dicta, that it is not clear whether the general removal statute permits appellant's removal. Maryland Company in the 5th District, in the 5th Circuit. Finally, what could a removal do in this case? The case was dismissed in the District of Columbia Superior Court, again, under the decision cited by the appellee. All the district court could do was enter to the Superior Court ruling as a final judgment and presumably hear the appeal in this court. That is, however, is not what the district court did. It reached its merits, which it could not do without violating the faith and the credit. Thus, even if the appellant's positions were adopted, which appears to be supported by no precedents whatsoever, in contrary to the authority on the issue mentioned in Moore's, the district court's decision cannot stand. I yield back.
Just
Right?
a couple of questions. You still pursued your case with the district court, even though you had the case pending in state court, even though you believed it should not have been with district court?
Well, I didn't file it in district court, and it was dismissed in state court first on July 22nd, 2022. On July 25th, 2022, I filed an appeal in District of Columbia Appeals Court. On August the 8th, Honorable Rigsby sent it to mediation, voluntary mediation. On August the 11th, appellee filed for a removal. It was already dismissed in Superior Court. However, that was 31 days, which appellee was already time barred anyway from filing a removal.
Thank you.
All right. You have 2 minutes remaining, so you can use that if you want to in reply to either the amicus or to the government. But now we'll hear from the government.
Okay, I'll use my 2 minutes additional, my
Oh,
2 minutes left.
all right now, okay?
The amicus, it's impossible for the amicus to have judged this on the merits. For one, the amicus never cited Moore's federal rule, federal practice. The merits should have been cited as if the case was actually still pending in state court, but it was dismissed already. Because the amicus never brought up Moore, then the merits, it's an unbalanced opinion on the merits, because it was time barred. It was already dismissed in Superior Court. The District of Columbia Court of Appeals had already got the appeal and had already made a ruling, which their ruling was they sent it to mediation. So two things took place. It was time barred, and District Court of Columbia, Court of Appeals made a ruling. So now the government makes it seem as if the case was pending in state court. That's not true. It was dismissed in state court. Honorable Rigsby she didn't have the jurisdiction, so I had to further on. I had to go further and to the district court. She didn't have the jurisdiction to remove it from district court at that time.
All right, your time is up.
Thank you.
Good morning, and may it please the court, Jane Lyons from the U.S. Attorney's Office, and I'm here on behalf of the United States. Regarding the court's question from the briefing order, the government and amicus agree that the federal removal statute authorizes removal from the District of Columbia Court of Appeals. The reading urged by Mr. Harris in his briefs, and again this morning, is contrary to the plain meaning and purpose of Section 1442, and the court need not address any other issues in order to affirm the judgment below. I'm happy to answer any questions the court may have.
Do you have any questions? All right, thank you.
Thank you.
We'll hear from amicus, Mr. Beal.
Good morning. May it please the court. My name is Jeff Bealert. I was appointed to assist the court. Seeing that you don't have many questions, I don't know that there's much for me to discuss. The reason why I didn't cite more in my brief is because it was talking about removal to an appellate court. Here, the removal was to the district court. And I think Judge Childs, you already hit on an important issue, which is when Mr. Harris ended up in the federal district court, he had every opportunity to seek remand back to either the Court of Appeals or the Superior Court, if that's really where he thought he belonged. So the fact that he actually did litigate his case, filed an amended complaint, continued to be in federal court, I think he waived any argument that he would have had to get the case remanded. So I think that we've staked out our positions in the briefs, and unless the court has any questions.
All right,
Thank you.
thank you. Call the next case. Call the next case.
Case number 23-1236, Kimball Wind LLC petitioner versus Federal Energy Regulatory Commission. Mr. Coyle for the petitioner, Ms. Chu for the respondents, Mr. Ross for the interveners.
All right, Mr. Coyle, good morning.
Morning, Your Honor. I hope the podium's the right height. Can you hear me all right?
Yes?
Great, thank you. Good morning, Your Honor. May it please the court. My name is John Coyle of the firm Duncan and Allen LLP for petitioner Kimball Wind. This case ultimately turns on a question of statutory construction, and the correct meaning of Section 211A of the Federal Power Act. The Commission correctly held that the statute does not specify who may seek relief or who may obtain relief under Section 211A. The statute simply says that the Commission may order an unregulated transmitting utility. There is no dispute that the Western Area Power Administration is an unregulated transmitting utility to provide transmission services, and I'm summarizing, on rates, terms, or conditions comparable to those on which the unregulated transmitting utility provides service to itself. There is no clearer example that I could imagine of disparate treatment than the one presented in this case, where the Western Area Power Administration funded 1/3 of a network upgrade, a sectionalizing substation, and I'll be happy to explain in as untechnical terms as I can what that means, but there isn't really a dispute that it's a network upgrade.
When you say no dispute that it's a network upgrade, but the statute refers to transmission services and how those need to be comparable with respect to the costs.
That's correct, Your Honor.
And so that's what my question would be, that you're speaking of recouping your outlay of costs
Yes.
with respect to a network upgrade, but the
Yes.
statute refers to
Transmission services, that's correct, Your Honor, and at rates that are comparable to those that the unregulated transmitting utility charges itself.
Mhm.
In this case, there's no clearer example of disparate treatment. WAPA paid 1/3 of the cost of the substation.
No, but what I'm asking is that you're contending that upgrades
Yes.
flows into the definition of a transmission service?
Well, there's an intervening step, Your Honor, which is cost recovery under rates and the treatment of those investments. And in this case, the investments in the facility were treated disparately. Western recovers its investment through its rates, while Kimball Wind was directly assigned 2/3 of the cost, $5.93 million, and does not recover those costs through rates or any other arrangement. That is about as uncomparable an illustration of transmission service, which is being provided not to Kimball Wind, I'll concede, and that may be part of Your Honor's question, but to the purchasers of Kimball Wind's output. If your question is, where's the nexus to transmission services?
Correct.
Then, sorry to be slow on the uptake, Your
That's
Honor. Then the issue is, okay, the requirement that Kimball Wind absorb 2/3 of the costs of the network upgrade was imposed by Western as a condition of providing transmission service to its customers. The Municipal Energy Association of Nebraska, or MEAN, and its member utilities were municipal utilities in the state of Nebraska. In plain English, in order to move the output of Kimball Wind's generating facility over Western's transmission system, Western imposed this condition. The commission argues, well, but you're not eligible, Kimball Wind, for relief because you're not a transmission customer or an interconnection customer. And that's true. We never contended that we were. However, the statute, Section 211A of the Federal Power Act, is not so limited. In contrast to other provisions of the Federal Power Act, as the commission correctly held, Section 211A does not specify who can seek relief or who can obtain relief. What Section 211A operates on is transmission services and transmission rates.
And would you not consider what you were doing a construction service?
A construction
Service.
service. No, I wouldn't.
With respect to your
No, I wouldn't, Your Honor.
substation.
I wouldn't, because the only reason to do it was in order to enable the output of Kimball Wind's generating facility to be delivered to its customers.
But there are transmission service agreements, and you didn't enter into a transmission service agreement.
That is correct, Your Honor. There is no dispute here that Kimball Wind is not itself a transmission customer of the Western Area Power Administration, nor is it an interconnection customer of Western. However, Kimball Wind's customers are transmission customers of Western, and Kimball Wind was hit with 2/3 of the costs of this facility that benefits all transmission customers on Western's system as part of its customers, who are also Western's customers, efforts to obtain network transmission service through which the output of Kimball Wind's facilities would be delivered to those customers.
So we ultimately need to make a finding essentially that you would stand in the shoes of Western with respect to that transmission service.
Not that we'd stand in the shoes of Western.
Or have
Your
some
Honor.
type of affinity or agency or.
Well, I think what you mean to say, if I could, and I
Sure.
don't mean to put words
No,
in your
this
mouth.
is technical language, so help me out.
Is that it's not exactly that we stand in the shoes. It is that we have a sufficient relationship to Western's provision of transmission services at rates and
And I meant
terms
the
and
shoes of
conditions.
mean.
Sorry?
I meant the shoes of mean, but use your technical language.
It's fine, Your Honor. We don't exactly stand in the shoes of Mean, although we are aligned with Mean because we serve Mean.
Right.
We can't serve Mean without Mean obtaining the transmission service they need to take delivery. And Western's provision of that transmission service was conditioned on Kimball Wind funding 2/3 of the cost of a substation that benefits all users of the Western transmission system. I think that's about as plain as I can put it.
Okay, fair.
What do you say about FERC's characterization of Kimball Wind as an off-system network resource for Mean?
Honestly, Your Honor, I'm not sure what they mean by that. I think
I'm not
what I would suggest is the commission throughout the case has drawn the distinction, and I'll outline it for you, that Kimball Wind is not directly interconnected to the Western transmission system. And that is also true, and it is undisputed. Kimball Wind is directly interconnected with the 115 kilovolt transmission system. Sorry, I try not to speak in acronyms here. Kimball Wind is directly interconnected to the 115 kilovolt transmission system of the city of Kimball, Nebraska, and Kimball, Nebraska is interconnected with the 115 kV Archer-Sidney line that is owned by Western. So yes, there's an intervening utility, and we're not directly interconnected. I don't think that matters in the context of Section 211A. Section 211A does not say relief is only available to customers who seek interconnection service. It says the commission may order an unregulated transmitting utility to provide transmission services under terms and conditions or at rates that are comparable to the rates that it charges itself.
But it doesn't say to whom it is to provide transmission.
That's correct. That's correct, Your Honor. And I think that the statutory phraseology, if I could, is one of the important textual clues that the commission neglected to consider in its construction of the statute. What the statute focuses on, first of all, I mean, we have three textual clues here that the court should pay attention to in construing 211A. One is the commission's own recognition in its May 4th order that the statute doesn't specify who may seek relief or who may obtain relief under Section 211A. So the statutory text doesn't limit relief, number one. Number two, the statute's use of the word comparable as a test of what the commission may order to happen had a well understood meaning by 2005 when Section 211 was enacted. And this court in the Alabama Municipal Electric Authority case that we cite in our reply brief, in particular 662 Fed 3rd at page 574, speaks at some length about what comparability means. It was a change in the commission's policy about what is undue discrimination, which is prohibited, as the court is aware, under other provisions of the Federal Power Act. The commission changed its focus on undue discrimination to say it is not so important that an actor, a utility, discriminate among classes of customers. So the focus on comparability goes from being horizontal, if you will, discrimination among different classes of customers, to being vertical, Does the utility treat people the same way that it treats itself? Does it treat those who use its system the same way that it treats itself? And in this case, that is clearly not the case. You cannot imagine more disparate treatment. I'll recover my investment, you don't recover yours. And by the way, you're going to eat 2/3 of the facility. Finally, under Section 211, the focus is not on actors, it's on action, it's on transmission services. So the attempt to say, well, the statute is limited, or it's limited in this case, to the provision of relief to transmission customers or interconnection customers has no basis in the statute. The commission is engrafting that requirement, which we submit is contrary to the language, the plain language of the statute. In order to justify, and this is my second point, in order to justify what it's done, the commission then dances the flamenco on generations of precedent that say you can't directly assign the cost of network upgrades, which is why Judge Childs, I use the expression network upgrades. Network upgrades benefit every user of the system. There is a clear line of commission precedent cited in our briefs that sectionalizing ring buses because they improve the reliability and availability of a critical transmission line are network upgrades. Again, that isn't in dispute as far as I'm aware, and the policy
But
behind
your
it.
ultimate relief you're seeking is the refund of your construction costs.
Yes, Your Honor.
Okay, so here, the statute is indicating that the unregulated transmitting utility can't offer itself rates that are less than comparable to another.
Yes.
So how does refunds fit into this statute?
Right. So there are a couple of different ways to effect treatment of Kimball Wind's capital expenditures that do not discriminate against Kimball Wind. One is Western includes its investment in rate base and through its transmission rates receives a recovery of and on its investment. Okay? They could treat Kimball Wind's investment the same way and pay off Kimball Wind's investment over time through transmission rate credits, which would be provided to MEAN or its members. And there would then be a third-party agreement which would flow those payments back to Kimball Wind.
Well, you
But
could have entered into such an agreement, but you didn't. The question is what possible construction of the statute would authorize the commission to order everybody to enter into this agreement?
Well, I think, Your Honor.
It's well beyond the terms of an order to adjust rates or service or terms of service.
With respect, Your Honor, I would disagree. As we pointed out at some length in our pleadings, the commission does this all the time in connection with generator interconnection.
Well, not under this statute. It's dealing with an unregulated
Correct.
utility.
Correct.
It's got basically a limited sovereign waiver of sovereign immunity
Yeah.
to, which this is what this is, to order them to do things. Go ahead, finish how you can finally, it's true, everything that you've said applies fine outside of this statute.
Yep.
And how you've described FERC's practice is accurate, I believe, too. It's
Yep.
just that you have a problem. You're operating under a very limited grant of authority and discretionary authority, I might add.
Let me take the second point first, Your Honor, since I got about 30 seconds left. This case does not involve an exercise of commission discretion. It involves the commission's interpretation of the statute. If that interpretation is incorrect, and it is for the reasons we've shown, then the commission's order is arbitrary and capricious. So discretion is reviewable in this case. And in this case, the erroneous construction of the statute makes the ruling arbitrary and capricious. Get back to whether Section 211A authorizes the commission to direct comparable treatment of Kimball Wind's investment in this facility. It does, clearly it does. Under both rates and terms and conditions of service, all the commission would have to do is to say, which it has done in other contexts under Section 211, direct the Western Area Power Administration to enter into an arrangement. They don't have to specify the arrangement. Enter into an arrangement with Kimball Wind, and if necessary with Mean, that does not treat Kimball Wind's investment in this facility on a disparate basis compared to what the
That
commission.
could even be a lump sum, the way you described it. Just could pay them $5 million.
It could, but, excuse me, but the commission
Seeking
doesn't.
reimbursement or a refund from a statute that is all about very limited relief.
Well, it's about rates being comparable, Your Honor, and the rates that are involved in this case and the terms and conditions of service in this case are not comparable.
Initially, there was some discussion, at least meeting notes reveal, of doing a third-party agreement with respect to the 2.2 million, which I guess became 2.9, but never with respect to this portion.
Your Honor, I don't.
Why is that? Why
Well,
did you enter into such?
Your Honor, I don't believe that that point was clarified, and the chronology is a little murky about when Western said our commitment to provide transmission rate credits is limited to money that we were prepared to spend to upgrade Kimball Tap, which is what the Kimball substation used to be. That, I believe, did not arise initially, and it was Kimball Wind's understanding, at least, that it would be receiving transmission rate credits through its customer Mean.
What shows in the, what's the record show about that? Where is that?
Pardon me, Your Honor.
193.
It is,
The notes of the meeting. That's on.
yeah, I think that's
Number 8.
that's correct, Your Honor. That is the correct reference.
That's it? Well, that's the one in which, so they're saying network credits will be applied against Mean's transmission bill, and Mean will then pass the credits on to Kimball Wind. A three-party agreement will be established. Well, it didn't happen.
Right.
And it was only with respect initially to, the notes reveal, it's not clear on that. So yes, the estimated cost of 2.2 million. In any event, why didn't you do it? You didn't do it. That's the problem.
Well, Your Honor,
Well,
it is.
Somebody pulled out, right?
Your Honor, it is inevitably the case that a party seeking transmission service, or seeking, in this case, to be designated as a network resource, has a choice either to honor its contract with the purchaser of its offtake or not. In this case, the transmission service was necessary in order for Kimball Wind to deliver its output to the customers under its power sales agreement. Now,
But since it wasn't interconnecting directly, it should have sought some arrangement to secure its.
well, Your Honor, it tried, and I think the record honestly reflects that they thought they had, or that would be an item for discussion later. But in fact, you're right. Kimball Wind was not offered a choice. They were told, if you don't pony up the money, Western says, we're not going to provide transmission service. The contract, the power sales agreement between Kimball Wind and Mean had a rather strict deadline in it as to when delivery was supposed to start, that did not admit of Kimball Wind going off and trying to build its own transmission network or find some other means of delivering the power. There was no other option for it. The same situation arises, for example, in Western Mass Electric. In this court's case, Western Mass Electric 165 Fed 3rd, where there was a contract in place under which an interconnecting generator had agreed to fund network upgrade costs. The commission said, we don't care what contract you signed. The fact of the matter is this isn't comparable service. It's therefore not permissible. In that case, under Section 205 of the Federal Power Act, in this case, we argue the same principle would apply under Section 211A because the statute says the commission may direct an unregulated public utility to provide transmission services on a basis comparable to those that the unregulated transmitting utility provides itself. It's not that complicated. And I'm way over time.
Right, we'll give you a couple of minutes to reply.
Thank you.
Ms. Chu?
Good morning. May it please the court, Susanna Chu for the Federal Energy Regulatory Commission. If I may, let me try to follow up on some of the the factual questions that Judge Ginsburg, I believe, was asking, relating to the approximately $2.2 to $2.9 million in network upgrades that WAPA reimbursed to itself. At JA 183, you will see that the facilities agreement from 2017 specifies that $2.2 million, that was the current estimate at that time, qualify as network upgrades and are eligible for network credit. Then further down on that page, it provides a cost estimate as to the rest of the upgrade costs. And it makes clear that these are not the remainder of those costs, the costs that ultimately were footed by Kimball Wind, were not considered network upgrades. These are a different category of costs. So despite knowing this, Kimball Wind in 2018 entered into a construction contract under which it agreed to pay for those upgrade costs. So it went into the contract discussion and signed the contract fully aware of how these costs would be allocated. Judge Childs, you were asking about how refunds fit into the statute, and the short answer is that they don't. Under 211A, as you were discussing earlier, the question is whether there is a unregulated transmitting utility that is providing transmission service on terms that are not comparable to the services it's providing to itself. So there's a real disconnect here between what Kimball Wind is asking for and what the Commission has authority to order under Section 211A. As the Commission recognized in the complaint order at paragraph 47, JA 378, there is no provision of the Federal Power Act that grants the Commission the authority to order refunds by governmental entities like WAPA that are exempt from the Commission's jurisdiction under Section 201F. That's the general exemption provision. It's 16 USC Section 824F. So the Commission here is acting as a creature of statute, and it's applying the provisions of Section 211A to this contractual situation. And it found that there's no transmission service agreement, no interconnection agreement that it has the authority to reach. My friend, Mr. Coyle, referred to the Western Massachusetts precedent. That's a Commission order in which the Commission did order a jurisdictional transmission provider to provide credits for network upgrades. But a couple things there. First of all, that was a generation plant that was directly connecting to a transmission provider. Those parties were jurisdictional. There was a generator interconnection agreement that was within the jurisdiction of the Commission to regulate. And moreover, in that case, the Commission actually was assessing witness testimony about whether the enhancements actually benefited the entire system rather than being enhancements that were solely for the purpose of interconnecting that particular generator.
You do indicate that the statute does not specifically speak to who can obtain relief. And so therefore, we allow Kimball Wind to petition. And also because they do have an order that affects them, so that's why they're here. But then you separate that from that they can't get relief under this statute. So what are the circumstances that Kimball Wind would be under the statute?
Right, so that's
the who.
That's right, Your Honor. So of course, yes, the Commission said that it was fine for Kimball Wind to come before and ask for relief, but it was not actually entitled to relief under 211A. And I think that goes to the Commission's findings that there's no transmission service agreement and Kimball Wind or interconnection agreement, and Kimball Wind isn't even asking for one of those agreements from WAPA. So there's a real contractual disconnection there. But moreover, the Commission also found that Kimball Wind and WAPA are not similarly situated for purposes of this statutory provision. As Mr. Coyle was explaining, the concern under Section 211A is that the transmitting utility needs to be treating the interconnection customer, the transmission customer, on comparable terms that it's treating itself. But here, the Commission explained in the rehearing order and in the complaint order that they're not similarly situated. This is at a rehearing order, paragraph 18, JA 390. The commission said that the amount that WAPA paid for its upgrades were incurred in its capacity as a transmission provider. And these were part of previously planned reliability upgrades. WAPA was already going to do something at that substation to increase the reliability on its grid. And then the costs assigned to Kimball Wind, said the commission, were due to the designation of the off-system Kimball facility as a network resource for Mean. So they're just not, they're not in the same shoes, Kimball Wind and WAPA. WAPA is acting as a transmission provider. Kimball Wind is not even a generator in this situation. It's an off-system resource.
Well, it's a peculiar term, as opposing counsel pointed out. But I mean, it is generating power.
Yeah, oh, yes, Your Honor. I know, and I understand it. It's a bit of a complicated circumstance in terms of the actual connections.
A generator. Would that make a difference here?
No, I don't think it would make a difference. I mean, it is a generator. It's just that it is not directly interconnected to WAPA. It's interconnected to a transmission line owned by a party that's not before the court, the city of Kimball. And it's the city of Kimball's transmission lines that are connected to WAPA. I think, and I don't,
Now,
sorry.
instead of a third-party agreement, well, pardon me, instead of a credits going back from Western to first to the city and then to Kimball. Could Kimball have entered into an agreement to sell power to the city at a price that would have reimbursed it for this, and then city then selling the power to Western?
Well, I'm not sure, Your Honor, because the city, I believe, is just a transmitting. Well, I'm not sure if the city wanted to purchase power, but the arrangement, I think sorry?
Probably just not. I mean, that's a complication for them.
Right.
But it does seem to me that with a little bit of foresight, this could have been worked out for Kimball.
Well, Your Honor, actually, I think the answer is here that Kimball has a long-term power purchase agreement with Mean, the municipal agency. And Mean is the actual transmission customer, right? Mean actually contracts with generators and it contracts with WAPA and other transmitting utilities to bring power to its own customers. So what happened here is there's a 20-year power purchase agreement between Kimball Wind and Mean, which is in the record. And that shows that Kimball Wind is receiving 20 years of compensation for all the output of its 30 megawatts of wind generation. So Mean, of course, is not here before the court, but it would seem to me that those contractual arrangements, those are the compensation that Kimball is receiving, and the amount that it has to pay for upgrades necessary to bring its power to its customer, Mean, are basically the cost of doing business. I mean, this is all outside the record. I'm sorry.
Apparently you found it acceptable, right?
Yes, apparently they did.
183, where you this is the facility study done by Western.
By WAPA, yes, Western, yes.
Says if the requester is Kimball, right?
The requester was Mean in this facility,
sorry.
says, because the Mean was requesting the study. But after the study, Mean.
Choose it to construct, if they could choose it. So ultimately they engaged Kimball to construct, is that how it works?
That's right. My understanding is from the Kimball complaint, after the facility study, Mean informed WAPA that any contractual arrangements would need to be negotiated directly with Kimball. And so Mean stepped back. And Mean it's not before this court. It didn't participate actively in the agency proceeding either. So you're right, Your Honor. So JA 183, that's the notice from 2017 about all of the costs and how they would be allocated. And at JA 215, that's the contractual provision providing for the compensation. It specifically says that Kimball Wind, upon execution of this contract, will advance to WAPA the sum of $4.28 million. So Kimball went in with eyes wide open and entered into that contractual agreement. And what's happening now is the contract is what governs that relationship, and the commission simply doesn't have the authority to go in and rewrite those contracts for Kimball Wind. There's just no basis for it in the Federal Power Act.
Under 211A, do you read that to say that only a transmission customer can obtain relief?
I think under 211A, Your Honor, it would be a transmission customer or someone who's asking for interconnection. So a customer or someone asking to become a customer. And these relationships are governed by transmission service agreements or generator interconnection agreements, neither of which are present here.
And in terms of how we would write our opinion, would your suggestion, if we were to rule for you, be that it be narrowly constructed to just say the relief is not there because the statute does not provide for the refund, and then that be it, not go into who's a customer, who's not, is there a transmission agreement, services agreement, et cetera?
If the court were so inclined, I think that would work just fine. I don't know that it's necessary to go into all of that. I mean, that was one of the bases for the commission's decision. But I think that is, that's certainly one of the bases for the commission's decision as well, that there's just no, what Kimball Wind is asking for is not covered by 211A.
All right, thank you.
Thank you, Your Honor.
Mr. Ross?
Thank you, Your Honor. Kason Ross for the Western Area Power Administration. I think I'll pick up on a theme that Ms. Chu concluded with, namely this dispute concerns terms of a contract that was duly agreed to by WAPA and Kimball Wind. And after Kimball Wind received the benefit of its bargain with WAPA, it's now asked FERC to unwind the terms of that duly agreed to contractual arrangement under Section 211A of the Federal Power Act. But that provision provides FERC only limited authority to oversee unregulated transmitting utilities like WAPA, and provides the Commission authority to direct WAPA to provide transmission services on terms that are not discriminatory or preferential. But as Petitioner's Counsel admitted this morning, WAPA is neither a transmission provider nor an interconnection provider for Kimball Wind itself. Nor did Kimball Wind ask WAPA to provide those services. So FERC understandably rejected Kimball Wind's petition, concluding that it lacked the statutory authority to provide the kinds of relief that it requested. As Judge Childs recognized this morning, essentially what Kimball Wind has asked for is a reimbursement for the terms of its contract. And as Judge Ginsburg recognized, that could have been contemplated by a three-way crediting agreement with the Municipal Energy Agency of Nebraska. But those are not the kinds of relief that Section 211A contemplates, which is strictly the provision of transmission services. Neither of those terms, either a refund for a contract that was satisfied and that Kimball Wind has now benefited from, nor a crediting arrangement with another municipal agency that is not before this court and which did not participate in the underlying contract at issue, would be properly contemplated by Section 211A. As Judge Ginsburg recognized, some foresight might have avoided this entire dispute, but that foresight would have required the participation of another agency who simply opted not to participate in this arrangement, the Municipal Energy Agency of Nebraska. Ultimately, Kimball Wind's dispute may be with them, but that is not the kind of relief that FERC can provide under Section 211A of the Federal Power Act.
Can I ask you, I've got a chart that says Kimball Wind has an interconnection and wheeling agreement with the city of Kimball. The city of Kimball then has an interconnection agreement with you all, with Western.
Mm-hmm.
What would it have taken, what type of agreement, if possible, would it have taken for Kimball Wind to be a customer direct or indirect of Western?
I'm not sure, to be completely honest with you. I think the initial three-party crediting agreement that WAPA would have entered into with Mean and Kimball Wind would have been some semblance of the terms that you're describing, Judge Henderson, but it's not clear. And under the terms of that arrangement, so far as I understand, WAPA would have provided network credits to Mean, and Mean would have passed through the value of those credits to Kimball Wind. Indeed, that's one of the forms of relief that Kimball Wind has sought from this court, and which the commission reasonably determined it could not provide under Section 211A. But irrespective of that, the characterization of the relationship between WAPA and Kimball Wind, it's clear that, as petitioner's counsel admitted this morning, Kimball Wind is not either type of customer, either an interconnection customer or a transmission service customer of WAPA. Now, Mean is, but that does not affect the analysis here, as the commission reasonably determined.
Well, FERC called it an off-system network resource. Is that a term of art?
There again, I'm not sure. I think in FERC's presentation this morning, it suggested that that was simply a characterization of the fact that the Kimball Wind facility does not directly connect to WAPA's transmission network. As Ms. Chu explained, there is a portion of line that's owned by the city of Kimball, Nebraska, that's not owned by WAPA, and that line connects to WAPA's transmission network. And so I think that's why it would have been referred to as an off-network source, but I'm not entirely certain.
And how did you determine the allocation of costs between you all and Kimball Wind?
I think that was just the nature of the contractual agreement. The $2.2 million that WAPA agreed to pay was previously ascertained costs to upgrade its network. And then the initially, I believe, $4.2 million, which ended up being nearly $6 million that Kimball Wind would pay, were simply upgrades to WAPA's substation in Nebraska to be able to facilitate the provision of power from a larger wind farm. I believe initially it was a 15 kilovolt wind farm, and now it's a 30 kilovolt wind farm. But in order to provide twice the amount of electricity, WAPA needed to upgrade its substation to accommodate that larger flow. So I think that was just agreed to through the course of negotiations. And as Ms. Chu explained, that was a duly agreed to contract between Kimball Wind and WAPA. There's no argument here, so far as I understand, that there was any kind of malfeasance in the negotiations. And in fact, so far as I can tell, Kimball Wind is receiving the benefit of that bargain by providing energy to residents of Nebraska and other Western states.
It's actually a fair inference that since they went ahead with the construction, even though that cost was allocated to them, that they regarded the revenues from the 20-year sale of the wind as sufficient to make it still a profitable investment. This would be a double recovery.
That's certainly possible, but I think maybe a better question for Kimball Wind's counsel on rebuttal.
All right.
Thank you, Your Honors. We urge the court to deny the petition.
Let me start with something that seems to be troubling the court, which is, assuming that you rule in Kimball Wind's favor and remand the case to the commission, what does the commission do on remand? The commission has authority on remand under the statute, the plain language of the statute, to direct Western to provide transmission service for the delivery of Kimball Wind's output on the same basis as it does other generation that's on that system. What that would then require, in our view, is for Western to reevaluate its disparate treatment of Kimball Wind's contribution to the capital costs for Kimball substation. The commission does not have to say refund. It doesn't have to say network credits, although those are two obvious ways to affect the relief. But what would happen in the ordinary course is the commission would direct Western to reconsider its treatment of Kimball Wind. The idea that there is a contract in place doesn't differentiate, and I mean the Western construction contract 2913, does not differentiate this case in any material basis from any of the other cases in which interconnecting generators were compelled to execute interconnection agreements with transmitting utilities, which were subsequently found by the commission to be unjust and unreasonable because they did not provide comparable service. Yeah? The direct assignment of network upgrades is flatly prohibited by other provisions of the Federal Power Act. It's not comparable service, and it can't be comparable service here, period, full stop. I wanted to respond briefly to Judge Ginsburg's question about double recovery. It's not double recovery, Your Honor. There was no budget anywhere, no indication of a budget anywhere for the $6 million that Kimball Wind got stuck with on this deal. What it had a choice, Kimball Wind had a choice to do was to comply with its contract with Mean or not. And what Kimball Wind did in this case was to honor the time-honored labor setting, work now, grieve later, okay? Get the power flowing, get the facility built, figure out the cost allocation later on. And that's why we're here. The other point I wanted to raise briefly, Ms. Chu made a couple of references to this being different, that because Western had planned on spending $2.2 million on upgrades, that Western's contribution to the Kimball substation costs is somehow in a different category than Kimball Wind's contribution to those costs. And that's just nonsensical when you think about it. Allocating the cost for the same facility on a different basis, one where Western gets rate recovery and the other where Kimball Wind has to absorb its $6 million share directly, is not in any sense comparable. And again, this situation is no different than the situation that the commission has confronted in connection with other interconnection cases, where a transmitting utility argues, well, we would not have to have incurred this cost but for this utility's interconnection. That's exactly what this is. It's a but-for argument. We, Western, would not have had to upgrade Kimball Tap to Kimball Substation if Kimball Wind hadn't come along and wanted to put its energy on our transmission system. That's fine. But the point, the commission's analytical point in all of the case law that it disregards in this case is that really doesn't matter. Causation is not important. What is important is that every user of the system benefits from that sectionalizing substation. And that is a fact. That is an ineluctable fact, well settled under commission precedent, which everybody seems to want to ignore. I thank you. I have nothing further to add. I appreciate the court's time.
All right, thank you.
This honorable court now stands adjourned until Friday, October 11th at 9:30 a.m.